Okay, Stacy, why don't we go ahead and get started?
Perfect. Thank you. Welcome, everybody. Thank you so much for joining us today. We really appreciate your time. My name is Stacy Piazza. I'm the Executive Vice President of Compliance and Recovery Solutions at Sanderson Firm, and I'll be your moderator for today's presentation. Before we get started, I just wanted to go through a couple of housekeeping items. First, copies of the PowerPoint as well as a link to the webinar will be available after the webinar. So if you are interested in receiving a copy of the PowerPoint or a link to the presentation, please email Heather or Brendan. Their email addresses appear on the screen now, and I believe will also be at the end of the presentation as well. We are going to try as hard as possible to leave time for questions at the end, so please feel free, if any questions arise, to populate them in the chat box. Sometimes we'll stop if it's relevant to the topic and answer them then. Otherwise, we will try as hard as possible to answer them at the end. And if we don't get to any of them, we're certainly happy to address those via email after the webinar as well. And last but not least, we will have a survey that will follow the presentation. It's a very quick survey. We really would appreciate your time just answering a couple questions, giving us some feedback on today's topic, any upcoming topics that you'd like to see. So first, I am going to introduce our speakers. We have Heather Sanderson. She's the president of Sanderson Firm. For many of you may know her on the call, but for those that don't, Heather has dedicated the majority of her 15+ year legal career to Medicare secondary payer compliance specifically. She has worked for several of the largest MSP compliance vendors, most recently the chief legal officer at Franco Signor. She launched Sanderson Firm in 2021 to continue her passion for advocacy and education to the MSP industry. She's participated as an expert witness, lobbied Congress for MSP reform, and is an awarded blogger and nationally recognized speaker on MSP. So we're in good hands, also known as the guru of Medicare secondary compliance and Medicare secondary payer compliance. Joining Heather today is Brendan D'Souza. He's a managing attorney with Sanderson Firm. Brendan also recently worked for Franco Signor as legal counsel. He has been in the Medicare secondary space for about 5 years and joined Heather at Sanderson Firm in 2021. Brendan has significant experience specifically, with anything legal, MSP opinion letters, settlement agreement reviews. He also has significant success with ALJ hearings, and prior to joining Sanderson Firm, he was actually an insurance and reinsurance attorney at an international law firm. So we're really pleased to have both of these expert speakers. You're in good hands with both of them. We're going to take you guys through some really critical stuff about avoiding pitfalls in Medicare claims practices. So without further ado, I'm going to turn it over to Heather. She will kick off our presentation.
Thank you. Thank you so much, Stacy. And thanks, Brendan, for joining us today. And thank you for all of you joining us across the country today. The goal with today's webinar was I want to do a little bit of foundational laying about, Medicare secondary payer. But what I really want to talk about are what are the present issues in Medicare secondary payer compliance right now, and how can you best overcome those given the current landscape. And, we're at a critical time of the year. Q4 is right around the corner, and I know we want to get those, old dog Medicare claims wrapped up before the end of the year. So let's see if we can give you some strategies today to take away back to your claims organizations that will be helpful to you. As Stacy mentioned, if you have questions, we'd love to help with those. Those give us some practical scenarios that you all are encountering out there. So feel free to type those in the Q&A chat function. We're going to talk about the 3 pillars of MSP today, right? So 3 pillars of Medicare Secondary Payer Act compliance would be Medicare set-asides. That's the future medical component. Obviously, there's conditional payments. These are Medicare liens. Those are those payments that Medicare has made pre-settlement to which they're owed reimbursement. And the last pillar of MSP, Section 111 reporting. So what I'm going to do first is kind of lay a foundation of what these items are, just for those of you that might be newer to claims. And then we're going to talk about what's going on in those individual areas right now. What's hot in MSAs, what's hot in conditional payments, what's hot in Section 11 reporting. Not hot in a good way, right? Because it's probably more frustrating than anything, right? At this point in time, there's some scary proposed rules on deck right now. And, Medicare is ready to ramp up their enforcement with the MSP. So we want to be ready, and that's the point of today's presentation. Talk about those current focus areas of MSP enforcement and where you need to focus your efforts right now. Of course, we're going to talk a little bit about how Sanderson Firm can help, and we'll take some Q&A at the end. So let's dive in, right? So talking about the first pillar of Medicare secondary payer compliance, Medicare set-asides. Many of you are familiar with Medicare set-asides, particularly if you work within workers' compensation claims. These are a report which predicts future medical treatment that would otherwise be covered by Medicare. This is a projection of future medical care, and it is set aside in a separate interest-bearing checking account post-settlement, and the Medicare beneficiary is only supposed to pay for injury-related Medicare covered items and services that would otherwise be picked up by Medicare. This avoids shifting the burden of future care from that work comp injury onto Medicare. Now, there is some talk about liability Medicare set-asides, and we'll talk about that here momentarily. But for right now, I think most of us in workers' compensation, we're familiar with Medicare set-asides, and these can be submitted to Medicare for review and approval, but it is wholly optional. Completely voluntary process to submit an MSA to CMS. And we're also going to talk about momentarily some of the commotion that happened earlier this year with respect to non-submit MSAs, and kind of let you know where that's at now. Brendan, why don't you talk everyone through what the current submission thresholds are?
All right, so let's do it. So many of you are probably already aware of these thresholds, but it's important to at least note these thresholds starting out. So really, when it comes to submitting an MSA to CMS for formal review and approval, there's two sort of thresholds to keep in mind. Threshold number one, if the claim involves the claim is settling and involves a Medicare beneficiary, and the total settlement amount will be greater than $25,000. That's an area, there's an option where the parties may, if they choose, submit a formal MSA to CMS for review and approval. If the claimant is not a Medicare beneficiary, but they have a reasonable expectation of becoming a Medicare beneficiary within 30 months of the settlement, and the total settlement amount is greater than $250,000, that's a mouthful. In that case too, the MSA may be submitted to CMS for formal review and approval. Keep in mind, these are workload review thresholds. So a lot of times I see clients ask me, they say, hey, we've got this claim, for example, that involves a Medicare beneficiary, but the total settlement amount is going to be, let's say, $20,000, right? So it's under that threshold. There can be a misconception in the industry where clients see that and they say, okay, well, it's below threshold, so that means that we don't have to prepare an MSA at all. That's not necessarily the case, and you'll kind of see that play out in a later slide where CMS has issued guidance on that. But these are not safe harbors, right? Just because your given claim does not meet one of these thresholds does not mean that an MSA itself is not appropriate. It just means that the MSA cannot be reviewed and submitted to CMS. And then just lastly here, when the MSA proposal is submitted to CMS, technically the WCRC, the Workers' Compensation Review Contractor, the WRC will do the initial intake, they'll make a recommendation, and then they'll forward that along to the CMS regional office to then make a final determination on whether the MSA proposal is approved or whether it is, denied or, counter-hired, so to speak, where CMS sort of says, hey, we disagree with the proposed amount, and so they return a higher allocation amount.
Very good. So, and so Brendan was just alluding to this, right? So situations where you do not have a settlement which meets Medicare's review thresholds. Brendan was just talking about how there's a misunderstanding that if you don't meet CMS's review threshold, that you don't need a Medicare set-aside, and that's not the case. In fact, here's two examples that we have up here on the slide. These are taken directly out of the WCMSA reference guide. So that's the guide that CMS produces indicating their guidance around protecting Medicare's interest with regard to Medicare set-asides. And so in example one, you have a scenario where you have someone who's Medicare eligible, they're 67, they're eligible for Medicare, but the total value of the settlement is only $17,000. And Medicare indicates under this scenario, they still expect some kind of, obviously it would be a non-submit Medicare set-aside, right? Because CMS would not review the MSA, some kind of future medical allocation to protect their interest. In example two, we have someone whose reasonable expectation of Medicare entitlement, but the total settlement is looking to be, you know, $225,000. And again, this would not be a case that's eligible for CMS review under the current standards, but not establishing some plan for future care places settling parties at risk. So again, you know, Medicare's workload review thresholds are just simply a workload threshold. And, you know, in all settlements involving reasonably expected Medicare beneficiaries and current Medicare beneficiaries, we need to consider Medicare's interests.
Okay, and so what happens in instances where either CMS workload review thresholds are not met, or, you know, let's say review thresholds are met, but the parties just choose not to go through CMS's formal submission process? In that case, luckily, the parties have options. And one of those options is prepare an evidence-based MSA, or at least an MSA that is based upon evidence-based guidelines. The two big guidelines here are ODG guidelines, official disability guidelines, and ACOM guidelines, American College of Occupational and Environmental Medicine guidelines. These are basically national guidelines used by medical providers or, you know, nurses, clinicians, where they're literally guidelines. They'll say, you know, if this person suffered a certain sort of injury, and this is, you know, the current type of condition that they're suffering from, these guidelines will basically come up with suggested treatment plans, be it medications, or diagnostics or x-rays or things like that. These guidelines sort of show what's appropriate for the particular injury that the claimant suffered. And when utilized properly, of course, these non-submit allocations that are prepared according to evidence-based guidelines are defensible and reasonable. And also keep in mind too, in the WCMSA reference guide itself, CMS also does note that the WCRC, that contractor, does at least review evidence-based guidelines when they're reviewing submitted allocations. So CMS itself does follow these guidelines.
Well, I think, you know, Brendan, that's an excellent point. So the WCMSA reference guide does state that the WCRC is to apply evidence-based guidelines to allocations upon the review. But unfortunately, this is one of those scenarios where, you know, CMS's guidance conflicts with what they actually do. For those of you that, you know, have experienced submitting WCMSAs to CMS, you probably are aware that, you know, CMS allocates in a worst case scenario sort of methodology, right? They're not really applying evidence-based guidelines as they're supposed to in their reference guide. I am a big proponent for evidence-based medicine in MSAs. I believe that the goal of workers' compensation is to improve outcomes for injured workers. And I think that the way that Medicare allocates in the review of MSAs is not to improve clinical outcomes. It is simply almost actually shifting the burden back to workers' compensation, employers, carriers, unfairly. And it's proposing a regimen of medical treatment that in a lot of cases, if implemented, could seriously harm or kill an injured worker. I've seen several, determinations from CMS, on Medicare set-asides where they're involved with an opioid regimen. And literally the opioid regimen as proposed for this injured worker, Medicare beneficiary, for the rest of their lifetime, if taken according to clinical guidelines, would literally harm them or kill them. Especially, Medicare beneficiaries can't withstand the same level of prescription drugs as people age, right? We can't withstand the same level of prescription drugs, and it's harder on our bodies. And these regimens are just unfair. And so my wish list would be that in the review process at CMS, that CMS really truly would apply evidence-based allocations. But for those of us that are choosing not to submit to CMS, right, we have that option of evidence-based guidelines. And so, a question I get a lot is like, what's the difference between a non-submit MSA versus a non-submit evidence-based Medicare set-aside? So now you can do a non-submitted MSA that kind of does an allocation style philosophy that would be applied in a traditional work comp MSA, right? And then you can also do a non-submit MSA, which applies evidence-based medicine. And so, parties have options. And the one thing I want you all to take away is that, under the Medicare Secondary Payer Act, the terminology Medicare set-aside does not exist in and of itself. There are Code of Federal Regulations. I have one up here on the screen, 42 CFR 411.46 D2, which indicates that to the extent settling parties in a workers' compensation claim carve out a portion of the settlement for future medical, then that will be the only portion of the settlement that needs to be exhausted before Medicare resumes payment, assuming the Medicare beneficiary exhausts that future medical fund, that MSA, right? It protects the rest of the settlement dollars. This regulation gives the foundation and the validity to non-submitted MSAs, and as mentioned within the reference guide in and of itself, Medicare does recognize that non-submitted MSAs are an appropriate way to protect Medicare's interests, particularly under threshold. And it does state numerous times throughout the reference guide that there are no statutory, regulatory, or legal guidelines requiring CMS to review an MSA. It is a voluntary process, and specifically the guide says, if you choose to use CMS's WCMSA review process, you have to comply with established policies and procedures, which means you must meet all of their documentation requirements. You must, wait for their review and approval, and you have limited, there's some re-review and amended review processes if you disagree with CMS's allocation or if the medical regimen changes, but these are sort of limited, whereas if you keep your MSA non-submitted, then you're going to have more appeal rates in the future.
Yeah, excellent points, Heather. And also keep in mind too, right? Evidence-based MSAs are defensible. I know many of you in the audience may be aware of a redacted letter that was sort of circulating around January of this year, which made itself present right around the time when CMS first updated the WCMSA reference guide to talk about evidence-based non-submit MSAs. So things to keep in mind about non-submit and CMS intervention. One, to the extent that parties use an evidence-based or a non-submit MSA in their settlement, and CMS sort of disagrees with the allocation, either A, feels the total allocation amount was insufficient, or B, feels that the MSA fund itself was exhausted inappropriately. Medicare, any intervention by CMS will come with administrative appeal rights. Medicare just can't deny a beneficiary's benefits outright without some sort of due process, right? So that individual will be presented with an opportunity to demonstrate that the MSA reasonably considered Medicare's interests through an ALJ, an administrative law judge. Also, a very, very, very important point here, if you're a claims organization who has a practice of using evidence-based MSAs or non-submit MSAs, be aware of your vendor or your law firm or your partner who's actually preparing or guaranteeing or backing up these non-submitted allocations. Different programs have different protections, I would say. So Sanderson Firm, for example, we actually provide indemnification to all the parties to the settlement. The plaintiff, the claimant, the claimant attorney, defense attorney, the employer, the carrier. Sometimes there's co-carriers, right? We indemnify them too. And we indemnify for the total exposure amount that the parties would face should CMS take issue with the actual allocation itself. That can't be said from all vendors or firms in the space, right? So sort of keep in mind or pay attention to what your vendor or your law firm backs. Sort of ask these questions, sort of figure out what's your true exposure and how much are you actually
Yeah, excellent points, Brendan. So, where did all this non-submit EBMSA commotion come about, right? Earlier this year, it was an interesting time. So on January 10th, 2022, for the first time, CMS updated their WCMSA reference guide with a new section 4.3 addressing their position on non-submit MSAs or evidence-based Medicare set-asides, right? So at first, the language was very strong. It was very contradictory. It was very confusing. It used some very strong language to basically say that, to the extent that Medicare had not reviewed a Medicare set-aside, that it would deny payment to the Medicare beneficiary up to the entire net settlement amount. And what happened after that was CMS heard from, a number of parties to the industry, including my firm. I was like, this is extreme, this makes no sense, and legally you can't put out such a policy, right? And then in February, Medicare hosted a town hall webinar, and they backtracked from their initial position. They received so much backlash on this first update that they stepped it back. And what they said on the town hall webinar in February is that nothing has changed. They were just asked to put out their position on non-submit MSAs, and that of course, to the extent they've not reviewed a proposed MSA, they can't know it protects Medicare's interest. Thus, they reserve the right to challenge the MSA, which was a big change in the language, which came out in January, where they said, they were going to automatically assume that because the MSA was not submitted to CMS, that it's a burden shift, right? And so, the language was changed now officially. They clarified section 4.3 in March of earlier this year to now, instead of saying they automatically will deny coverage, now it's saying they may, right? And that, as Brendan went over earlier, right, to the extent that Medicare does believe that a non-submit MSA is sufficient, which, by the way, they've never challenged a non-submit MSA yet to date. I attend many of these MSP conferences, and I'm in touch with everyone in the industry, and none of us have ever heard of Medicare actually challenging a non-submit MSA yet, even post-reference guide, right? I think they would be hard pressed. It's not like, particularly with our program at Sanderson Firm, I can't speak for others in the industry, but it's not like our workers' compensation, clients are calling us and saying, hey, Sanderson Firm, I'd like a $5,000 MSA today. No, it doesn't work like that. Like, we're looking at the medical records, and we are establishing a future care regimen that is in line with evidence-based Medicare set-asides. Right? We are making sure that there is appropriate treatment included in the allocation that will sufficiently cover the medical needs for the rest of this person's lifetime. So for Medicare to sit there and go back when we have all this documented, medical records and such, and to document why we included 3, physical therapy visits per year versus 5, right? We have an evidence-based guideline to support that. We have a state law principle to support that. These are legitimate MSAs, and as I talked about earlier, parties have the right to not submit an MSA to CMS. It is a voluntary process. So, and Medicare confirmed on their town hall on February, saying nothing from a legal, regulatory, or policy standpoint has changed with section 4.3. They are simply now just saying that to the extent they have not reviewed a non-submit MSA, they reserve the right to challenge it, which they always have, right? Of course. So, we've seen unfortunately, some misunderstandings, in the industry, some that have not become aware of the March update where Medicare stepped back their language. We've seen some misunderstandings, unfortunately, with some claimant attorneys and judges that are now assuming that because of section 4.3, especially the original version that came out in January, that now all of a sudden CMS submission is required. Brendan, maybe you want to speak a little bit to that, because I know you're dealing with that on a day-to-day basis with your files.
Yeah, that's so true. And it's a great point too. So yeah, I mean, this slide in particular, so predictions for non-submit MSAs going forward. Some of you may recognize the similarity between this particular slide that was a very similar slide that was on a previous presentation I think we did in either March or February earlier this year, where we sort of predicted this, right? Medicare comes out with the update to the reference guide, and there's scary language, and it sort of scares, not only carriers off, but it scares judges, applicants, attorneys, almost everyone in the industry. So you'll see the second bullet point here. One of our predictions is, applicants, attorneys, and judges will come to understand that CMS's position remains unchanged, really. I was involved in a conference call on a California claim not too long ago where a judge actually refused to approve a settlement just because a non-submit MSA was used. And in the order, this decision that the judge issued, the judge specifically referenced the reference guide. And there were a couple of issues with that. One of the issues was the actual reference guide that the judge was referencing was the original January update. So I had to get on the phone with the judge and sort of explain, hey, there's been an update since then, and Medicare has softened its position, right? So just because the parties to this case are settling pursuant to a non-submit MSA, Medicare does not deem that to be a burden shift. And of course, the judge sort of understood, and I provided her with the updated reference guide and policy language. She ultimately approved that settlement. So most of this is just a matter of education. It's going to take some time, but attorneys and judges alike will start approving these settlements without these sort of hiccups moving forward. And the first bullet point, of course, employers and insurance carriers will continue to use non-submit allocations, given that submission remains entirely voluntary, even when review thresholds are met. A lot of you in the industry may have noticed that there's current issues with submitting MSAs right now. If you were to ask me maybe a month or 2 months ago, what's the standard turnaround time on an MSA submission, I would have told you 20 days, and that would have been accurate. But as of the last month, several weeks, it's taken double, sometimes triple that time. And that's in cases where CMS does not even issue a development letter. That is a request for additional information. So, a lot of clients see this and they say, hey, we don't want to go through the process of waiting for CMS to return a decision in 60 days. We don't want to deal with, the increase, I'd say about 20% in additional development letters being issued. So we're going to go ahead and just skip that. And we're going to go with the non-submit route. And they're entirely within their right to do that. And then lastly, as I mentioned previously, to the extent that parties are wary of non-submits, just pay close attention to your law firm, your vendor partner, and the protections that they offer. Hopefully they at least offer some protections when it comes to non-submit evidence-based MSAs.
Perfect. Well, I think this is a good segue before we get into conditional payments and Section 111. For those of you that work with liability claims, right? What want to know this mythical unicorn of liability Medicare set-asides. Where is that at? Currently there is no process or procedure for CMS to review liability Medicare set-asides. However, Medicare has been looking to create a formal legislative rule around MSP and future medicals for some time now. We saw a proposed rule come out in 2012. There was an advance notice of proposed rulemaking. It was withdrawn in 2014. And then in 2020, we see this proposed rule come up again on the Federal Register as if Medicare is working on it. And so we've been keeping an eye on this now. We are aware that there is currently a proposed rule, the text of a proposed rule, which the abstract of the proposed rule says it will impact and will provide guidance and requirements around protection of Medicare's future interest as it relates to workers' compensation, liability, and no-fault claims. So this potential rule stands to impact MSAs in work comp and potentially impact existing processes that have been in place for over 20 years. It stands to potentially, for the first time, create LMSA requirements and potentially create no-fault MSA requirements. So we're waiting on this. We do know, as I mentioned, that the text of the proposed rule has been written. It's just a matter of when it's released. We are keeping an eye on this, but we also know that currently right now, CMS is looking to put out a bid for their workers' compensation review contractor, the WCRC, and potentially this new WCRC, it might remain the current contractor for the WCRC Capital Bridge, or it might be awarded to a new contractor. But whoever takes over the WCRC, the contract and the sources sought notice makes very clear that this contractor is not only going to have to review proposed work comp MSAs, but also liability and no fault MSAs as well. So, I mean, if you can kind of, read the tea leaves here, it tells you that there will be an LMSA requirement coming out here soon. All right. I think that should be it on LMSAs. In the meantime, take a look at your individual liability settlements with Medicare beneficiaries, and it should be a case-by-case decision on whether it's appropriate to include an LMSA. And in the interest of time, I think, Brendan, why don't you start us off about, some basics on conditional payments?
Yeah, so sure. So many of you are already aware, but let's start from the building block. So what is a conditional payment? A conditional payment is a Medicare payment for Medicare covered services for which another insurer is the primary payer, right? So if you're involved in a claim, either workers' comp, no fault, liability, during the pendency of the claim, the carrier may not be paying for the injured individual's medical services. So during that time, Medicare actually makes payments for the injured individual's medical treatment conditionally, right? So Medicare expects to be reimbursed on the back end when a settlement occurs for the payments that it made. So they're made on the condition. And lastly, of course, conditional payments are not only made by traditional Medicare, they're made by private Medicare plans alike. So Medicare Part C, Medicare Advantage plans, that is, and Medicare Part D, prescription drug plans. And courts have interpreted recovery rights for Part C and Part D plans to mirror or mimic Medicare's traditional Medicare's, that is Medicare Part A and Part B, Part B's recovery rights.
That's right. So, conditional payments are, they can be a headache, but they don't have to be. There's, ways and methodologies to stay on top of these. Brendan just mentioned, Medicare Advantage plans. I'll talk about that in a moment, because I did say at the beginning of this presentation, I want to talk about what's hot right now. And the Medicare plans are the ones that are, really causing a scurry. But, with traditional Medicare conditional payments, first off, you want to make sure that you're responding in the appropriate time frames. Some of the conditional payment correspondence coming out of Medicare and their contractors, particularly conditional payment notices, or CPNs as they're called, have a 30-day time frame for dispute or response, and we see a demand being issued. So we want to dispute these conditional payments in a timely manner. We want to pay attention to the time frames. You don't want any of your conditional payment debts ending up at the Treasury. It does happen to a lot of folks in the industry, but it can be difficult to pull back, and it's much easier if the dispute is kept at the contractor. Now, with Medicare Advantage plans, so we proactively recommend that parties, now that you're receiving the Medicare Advantage and Part D information, right, as part of the PAID Act, which I believe we have a slide on that later, I'll talk about it a little bit more detail then, primary workers' compensation, liability, and no-fault payers as of December 11, 2021 are now receiving Medicare Advantage, which is the Medicare Part C, the private Medicare, and the Medicare Part D enrollment information in your query response file when you're doing your query of Medicare status through the Section 111 reporting. And so now, to the extent you become aware of a Medicare Advantage plan, it may make sense to reach out to that Medicare Advantage plan to resolve any conditional payment liens pre-settlement, so that those demands do not come later in time. And it's important also to engage in, pre-settlement discussions with the Medicare beneficiary and or their attorney as to how conditional payment reimbursement will be handled. We do see in a lot of cases, this is sort of, unfortunately, we understand, because there's a lot of factors going into an agreed upon settlement, but when Medicare becomes an afterthought or kind of becomes a discussion point way at the end of the settlement timeline, it really can hold things up. So we recommend proactively addressing these sorts of issues early on. So PAID Act, I'm gonna take this, Brendan, because this is a cause that was near and dear to my heart, and did a lot of lobbying for this particular bill, because a couple of years ago, before the PAID Act, what we were seeing in large part is that, and we're still seeing it, but I'll talk about that in a moment, insurance carriers, before the PAID Act, you didn't know unless someone solicited the information to you pre-settlement that they were on a Medicare Advantage or Part D plan. You didn't know, right? Before the PAID Act was enacted, Medicare was only returning traditional Medicare Part A and B enrollment information to primary payers in the query response file. So again, there was no way to really know for sure. And then what was happening are that these Medicare Advantage plans, who are now getting these recovery rights similar to Medicare, as Brendan mentioned earlier on, double damages rights for carriers that do not reimburse conditional payments. They now have this double damages right under the Medicare Secondary Payer Act. We're seeing that happening, but no awareness on the primary payer side as to whether these injured individuals are enrolled in a Medicare Advantage plan. So in 2019, I actually served as an MSP expert in a large class action filed against a large auto carrier, for failure to reimburse the Medicare Advantage plan. And the class action was for double damages. And through discovery, it was very clear that, my client, the auto carrier, had never received any notice or opportunity to reimburse the Medicare Advantage plans, pre-settlements. That was back in 2019. And that was just one example of, this sort of litigation and this practice happening. And so we felt strongly that we needed the PAID Act. And all that we were asking with the PAID Act, it was a simple one-page bill asking Medicare just to return the Medicare Advantage and Part D enrollment information to primary payers so that you all, if you choose to, can reach out and proactively resolve Medicare Advantage plan and Part D conditional payments so that you're not hit with those double damages lawsuits and you're not receiving a conditional payment demand, post-settlement. So as of December 11, 2021, PAID Act has been enacted, right? So within a few months, we'll be at a year of this being in place, right? So if you're really taking a look at your query responses, you should be seeing at least the past 3 years of all Medicare Part A, B, C, and D enrollment information on your Medicare beneficiaries. And so this now allows you to, if you choose to, the PAID Act doesn't require you to reach out to the Medicare Advantage plans or the Part D plans to resolve conditional payments. What I'm saying is that it's a best practice because, like I said, there is risk of lawsuits, stemming out of the PAID Act and with this entity called MSP Recovery LLC, which is a law firm out of Miami, Florida, that has made a business out of the MSP double damages private cause of action and has sued nearly every insurance carrier and self-insured entity across the country. If they haven't found you yet, they will. They are heavily funded by private equity, and they're just filing lawsuits. They don't really even have all the information to know where the primary payers are, which claims belong, but they're throwing things at the wall to see what sticks, and that's unfortunate. So, addressing these Medicare Advantage plans, I believe, is very important, and proactively resolving them is a really important area of compliance right now. We are seeing, when I'm telling you right now, I wanted to talk about the hot areas with each pillar of MSP. For me, Medicare Advantage plans and their conditional payments keep me up more at night than traditional Medicare. Medicare, if they're not reimbursed, for the most part, they'll send debts to the Treasury, which can be, troublesome for Medicare beneficiaries with offsets of their Social Security benefits. It can be troublesome for entities that might have an offset of federal tax refunds and such until Medicare is reimbursed. But we don't really see Medicare file these double damages cause of actions. We haven't seen one in probably over a decade. But the Medicare Advantage plans and those entities like MSP Recovery LLC are certainly getting after it. And I'd say nearly at least twice a week, I'm receiving a LexisNexis alert of a new case being filed with this Medicare Advantage plan stuff, most particularly by MSP Recovery LLC. But sometimes the Medicare Advantage plans actually file lawsuits themselves, right? So we have 2 circuit court cases, out of the country that established double damages rights for Medicare Advantage plans. And both of those cases were filed by Humana Medicare Advantage. So just be aware of the Medicare Advantage plan issue. Obviously, you can tell I'm very passionate about it right now. It is an area of concern, and I think it's only going to grow.
Heather, we have 2 questions related to the PAID Act now. I'm not sure how we're looking on time, if you want to take those now or wait to the end.
No, that's fine. That's good. Let's take them now while we're talking about it.
So the first one, how do you get the information on who to contact for the Medicare Advantage plans? This is a real struggle.
Yeah, so that's a good question. So we do receive the mailing address and the information, the plan number as it relates to the Medicare Advantage plan enrollment. Now, Stacey, you've been working in your conditional payment division with these Medicare Advantage plans. Maybe you could shed a little insight on some recommendations. I know that, with some of the larger Medicare Advantage plans, they have a subrogation email address, and that's much preferred, but would love to hear your input on that.
Yeah, absolutely. So as you already mentioned, they are providing that detail in the response files, but what we have found so far and feedback we've gotten is that this information wasn't necessarily derived from the Medicare Advantage plans directly. It was sort of assumed by Medicare on who the contact would be, what the contact address would be. So we're finding a little bit of inaccuracy in that. I will say that if you are not receiving the data in Section 111, I know sometimes the claim systems based on IT resources aren't equipped to receive that information to date, but your beneficiary is on a Medicare Advantage plan and they say we're on Blue Cross Blue Shield. There's a directory that's actually available at cms.gov that you can download that will also have plan contact information. So you can look up the specific plan and you can find out who the contact is. And what I have found so far is that even if the plan contact information that they have is inaccurate, typically the person you're reaching out to will be able to navigate you in the right direction. Additionally, a lot of the success we have is just based on experience and, contacts that we have within certain organizations that just, we know that who Kaiser subrogation companies are from past experience, because they may vary by jurisdiction. So, obviously, those are some resources you can use on your own: the Medicare Advantage directory on CMS.gov, the information in the query response files, or you can certainly always reach out to Sanders and Furman at any time if you're having a particular struggle on one, and we can help complete the research for you.
Okay, great.
The next question: is there any indication that CMS will promptly provide, I think promptly might be the key word, provide Section 111 reporting information to Advantage plans and Part D plans?
Yeah, so we are aware, and Medicare does provide the Section 111 reporting information to the Medicare Advantage plans. They do share that, and that is how, and probably why in some situations you're receiving, conditional payment correspondence from the Medicare Advantage plan post-settlement, right? They are sharing your TPOC information, all the information as it pertains to the injury with the Medicare Advantage plans, and they are intended to be used for conditional payment recoveries.
Perfect. And one more just popped up real quick. What action, if any, do you recommend that the carriers take with receipt of the Medicare Advantage plan enrollment?
Yeah, so it's the extent you're aware of Medicare Advantage plan enrollment. When you are, getting within, I'd say, 60 to 120 days of settlement, I would recommend that there be an inquiry with the Medicare Advantage plan as to whether they have a conditional payment demand which they're seeking reimbursement for, so that you can wrap that up pre-settlement. Now, and again, I said this earlier, the PAID Act does not require you to do that. But what we're seeing is that, failure to reach out to the plans is going to result in those demands coming either post-settlement, or you put yourself at risk for, double damages lawsuits by MSP Recovery, for instance, who now says, well, you knew you had, Jane Smith was on Humana Medicare Advantage. You had that information coming back to you in the query response file from CMS. We know you had that information. You did nothing about it to reimburse the plan, and thus, you owe us double damages. So we recommend proactive, verification of any liens and reimbursement as necessary. I will say the Medicare Advantage plans are a lot more willing to negotiate, which is great. A little bit more willing and flexible than traditional Medicare, so that's nice. Usually we can get that number down.
Yeah, and one more thing I'll add, Heather, too. What's really interesting is you've got a lot of large Medicare Advantage plan providers, your Humanas, Kaisers, Aetnas, that are already experienced in getting lien requests and things like that. What we're seeing now is a lot of these smaller Advantage plans coming into play. So the other reason for being proactive is it could take a significant amount of time. As we mentioned, issues on finding the right person to contact. So, they're not as efficient, and they're also seeing an uptick in requests due to the PAID Act information that's being provided. So definitely want to be proactive as well due to the length of time it could take. It's going to be a little bit more cumbersome of a process in some cases than traditional Medicare.
Excellent point. So I'm not going to spend too much time here because we already went over this, and I want to keep moving forward, make sure we cover everything. But again, if Medicare is not reimbursed and Medicare Advantage plans are not reimbursed, we've got potential for litigation, Treasury referrals, and potential legal action for double damages. Brendan, why don't you, I was mentioning earlier, I would love for you to kind of give a little color around this case. I was saying earlier that what we're seeing is now, case law is starting to lean toward, to the extent you've reported a case via Section 111, that's constructive knowledge that, Medicare or Medicare Advantage has made a conditional payment. And I believe that was illustrated in this case. What are your thoughts here? I won't go into too much detail about the case, but let's talk high level. What did this decision tell us?
Yeah, so this was an interesting case, pretty recent, of course, as you guys can see here, August 10th of 2022. The main focus on this case in particular was really around the statute of limitations. The 11th Circuit in this case basically said that Medicare Advantage plans have a 4-year statute of limitations recovery period, which is something that, to my knowledge, is the first time that a court in any jurisdiction has ever reached that ruling. As most of us are aware, the federal government in recovering conditional payments has a 3-year statute of limitations recovery period. So oftentimes when the issue of statute of limitations and Medicare Advantage plan recovery is brought before courts generally just borrow the federal government's cause of action and use that 3-year statute of limitations recovery period. In this case, the court didn't do that. The court basically said, hey, there's actually another statute out there that's directly on point. And specifically, the court cited to Section 1658 of the United States Code. I don't want to nerd out too much, but if I could just read a little excerpt here. Basically, what that section says is, except as otherwise provided by a law, a civil action arising under an act of Congress enacted after December 1st of 1990, has a 4-year statute of limitations period. So basically, the question presented to the court was, does MSPA claims, right, the plaintiff here, who's an affiliate of MSP Recovery, does MSPA claims as civil action or lawsuit arise under an act of Congress enacted after December 1 of 1990? And the court basically said, yes, it does. The court said Medicare Advantage plans were invented post-1990. They were invented in 1997. And their recovery rights, Medicare Advantage plan, even Part D recovery rights, were formally acknowledged after 1997, after 1990. So because of that, the court, the 11th Circuit in this case, basically held that this particular Medicare Advantage plan, Florida Healthcare Plus, had a 4-year period to recover for conditional payments that they made and needed to be reimbursed. We can skip to that, yeah.
All right, well, yeah, in the interest of time, let's move on to Section 111 reporting. I'm going to quickly go through the foundation there and tell you what's going on there because, arguably this is an area that's, most threatening as far as penalties for non-compliance goes, right? But so for those of you that are not familiar, the reporting requirement was passed as part of the Medicare Medicaid S-CHIP Extension Act of 2007, requiring workers' compensation, liability, and no-fault insurance carriers, self-insured entities to report claims and settlements to Medicare where certain thresholds are met, right? And the whole point behind reporting was so that Medicare could now have visibility into settlements occurring with Medicare beneficiaries so that they could recover conditional payments and coordinate benefits, right? Prior to the reporting law, Medicare was shooting in the dark. They didn't know unless it was voluntarily reported to Medicare where a settlement occurred. So, the point is so that they can pay secondary, right? And so in 2010, the requirement to report went into effect, right? The law was passed in 2007, but didn't go into effect until, early 2010. And so basically the way I think about it is like step one, right? First thing you need to do is to, conduct a query on all of your injured individuals. There is a misunderstanding that only folks over the age of 65 can be Medicare eligible, and thus you only need to query those that are over 65. There's plenty of Medicare eligible folks out there in their 30s and 40s, and because they can become Medicare eligible after being enrolled in Social Security disability for 24 months or longer, and there's some other reasons as well, but the best practice is to query all your claimants, and you're going to need the big five, right? The big five data here as listed on the screen. And then if they come back to be a Medicare beneficiary, if you have a workers' compensation or a no-fault claim, you're going to want to report ongoing responsibility for medical or ORM, right? You're going to report when that's established. That's not necessarily the date of the first payment. It's the date that, there is a payment obligation should a bill be presented. Also, you're going to report your what's called a TPOC, total payment obligation to claimant, which is basically your settlement judgment or award when that occurs. And you're also going to, report your termination of ORM where applicable, right? So that's really important. Terminating when you have that ongoing responsibility for medical timely, and also making sure to report that TPOC timely. There might be other reportable events such as a change in codes, but we want to make sure that's up to date. And these are the key focus areas. Brendan, why don't you talk us through some of the most common Section 111 reporting errors that we might see here as we work with clients on the Section 111 compliance?
Sure. So the most common errors that we see, number one would definitely be ICD coding and ICD coding accuracy. A lot of the times you may settle a claim and you'll have a plaintiff or a plaintiff attorney who wants to release liability for all potential injuries. So if a person maybe, I don't know, fell and sprained their ankle, the plaintiff attorney might want to, include other potentially pre-existing injuries, right? And that's not good, right? Because to the extent that there is over-reporting or, reporting more ICD codes that are necessary, or that are really part of the settlement or part of the release, Medicare is going to seek recovery for all those items. And those are items and medical treatments that really the insurance carrier or none of the parties to the settlements should be responsible for, right? Because they're not related to the claim. Underreporting is another issue. Parties can report up to 19 ICD codes under Section 111. Not saying that you should exhaust those and try to hit that 19 figure, but that's just to say that you have room to report codes, right? So if there's a injury and that injury is going to be settled, it is alleged as part of the claim, that specific injury should be reported, right? No reason to omit any injuries. Not using specific codes, so best practice I'd say is you should really be using ICD codes when you can. ICD-10 codes, that is. ICD-10 codes are much more specific than the previous ICD-9 codes. So if you can, try to use ICD codes that'll minimize your conditional payment exposure, or at least should. And then also not updating the ICD codes through the life of the claim, right? This is a fluid thing, right? Individuals' treatment changes or gets better over time. So to the extent that something has fully improved and no further treatment is necessary, then ICD codes can be updated. Second thing is ORM termination. Just populating ORM termination when you can, right? So things that qualify as ORM termination events. Let's say the claimant or the Medicare beneficiary passes. That's an instance where the insurance carrier wouldn't be responsible for the payments because they passed and that person can't seek any further medical treatment, right? So that's an example of where ORM should be terminated to notify Medicare that the carrier's responsibility has ended. Final settlement, full and final settlement where future medicals are released. That's the reason to terminate ORM. Statute of limitations. Let's say there's a 3-year statute of limitations period for a certain injury, and it's been, 4 years, right? In that instance, ORM should be terminated. Also keep in mind, administrative closure of a claim. I see this a lot. It's really not a basis for terminating ORM. Medicare has clearly defined guidelines for when ORM should be terminated, right? So for the reasons that I listed previously, Medicare added a somewhat new ORM termination standard earlier this year, thankfully, because there have been instances where an insurance carrier would have to keep a claim file open for such a long time because let's say the statute of limitations was, maybe there wasn't a statute of limitations, right? You're in a state where open medicals are left open forever and you can't close out ORM. Medicare recently issued a guidance saying that if no payments have been made for at least 5 years, and the total claims paid on the file are less than $25,000, then in that case, that's an instance where ORM can and should be terminated. What else? Late reporting, right? So TPOC, total payment obligation to the claimant. A TPOC, that comes in the form of a settlement, a judgment, or award, but it's typically the case when a settlement has been reached and the Medicare beneficiary receives a lump sum payment in exchange for agreeing to settle their claim. That TPOC, that dollar amount, should be reported through Section 111 within at least a year of that TPOC. And lastly, SSN accuracy. So during your claim, right, the Social Security number is part of the Big Five data. So, carriers want to make sure that they have that and other data points to ensure that actually confirm that the claimant is not or is Medicare entitled, right? Because if the SSN, the Social Security number, is a match, that brings in Section 111 compliance concerns, and that brings in your reporting obligations. You want to make sure you're getting accurate SSNs as well.
Very good, very helpful. So, here's some best practices. As I mentioned earlier, you're going to want to query all of your claimants for Medicare status, right? You want to make sure that you're taking the whole population. If you have an individual that's refusing to provide their social security number so that you can conduct the query, you need to document those efforts to obtain the social security number. The proposed rule, which is what I really want to talk about in our last few moments here today, the proposed rule that is in the final rule format sitting at the White House OIRA office, ready for release by February of 2023, and imposing up to $1,000 per day per claim penalties against non-compliant primary payers, is very clear that Medicare wants to see diligent efforts to obtain a social security number. Within the proposed rule, Medicare actually stated that they would want to see at least 3 attempts to obtain a social security number, at least twice by mail and once by phone or email, or they were going to be able to levy a penalty against the primary payer. So collect those social security numbers, or make sure you're heavily documenting the attempts to do so. Make sure you're terminating ORM timely, right? Let's look at the NGHP user guide and what the guidance is around that. As Brendan mentioned earlier, administrative closure of your claim does not equal ORM termination. You want to make sure your conditional payment program is evaluating and verifying Section 111 data when handling conditional payment matters, right? Another area of focus that is likely going to exist in the final rule for Section 111 penalties, which it was in the proposed rule. Medicare was very clear in their proposed rule that they would issue a penalty against an insurance carrier or primary payer where the Section 111 data that's reported to Medicare actually contradicts what you are telling Medicare's conditional payment contractors. So for example, let's say Medicare's contractors have issued a conditional payment demand, and some of those charges are outside of your responsibility period, right? Your claim back to Medicare's contractors, I didn't have responsibility during that time frame, but you still had an ORM open on your Section 111 and didn't change that, right? So your Section 111 is contradicting your conditional payments. Definitely an area of focus for those Section 111 penalties, right? Make sure that you're handling the MAP notifications, right? Like you're taking a look at the Medicare Advantage plan enrollment information and doing something with it. And make sure that you're correcting all the errors that come back in your Section 111. There's a misunderstanding also that, if you do submit, claim records through Section 111, that you've now complied and forget about the errors. No, if you don't correct those errors, then it's not ever counted as reported. And so I mentioned there's a current, notice of proposed rulemaking on Section 111 that came out in February of 2020. It is supposed to be released by February of 2023. So that's what we're almost in October of 2022. We're just a few months out from Section 111 penalties. So now is really the time to make sure that you're getting your claims organization cleaned up, that you're cleaning up historical data, and that you're implementing good best practices to make sure that you're reporting all reportable settlements to Medicare and all of your claims with ORM to Medicare going forward, right? We know that the final rule for Section 111 penalties is sitting at the White House OIRA. You can see here on the screen, it's pending regulatory review. The text has been drafted and they're gaming for a release in early next year. So, make sure this is an area of focus for you. Take a look at what you're doing for Section 111 right now. Make sure you're collecting those social security numbers, make sure you're reporting, TPOCs timely, and make sure that you're terminating ORM. So I'm not going to go too much in depth. I do want to take questions. And I do want to, again, offer that we will share a copy of this presentation post presentation if you'd like to email us, but we can help with these concerns, right? We have a full suite of Medicare secondary payer services to include Medicare set-asides, conditional payment services, Section 111 reporting services. We also do some audits, and we've been doing some audits, claims organizations trying to get ready for these Section 111 penalties. Let us know how we can help. But I do want to jump over to the few questions we have left in the minute or so we have left. And again, thank everyone for attending today. Stacey, do we have time for a question or two?
We do. We have 3 questions, and I think we should have time for all of them. So the first question is, the 4-year statute of limitations in the Tower case, is that 4 years from initial treatment date or 4 years from when the Advantage plan becomes aware of the primary payer claim?
It's 4 years from the notification of the settlement, judgment, or award. So it would be the latter of that question.
Okay. All right. The next one, regarding the PAID Act, are there standards for proactively seeking conditional payments from the Medicare Advantage plans? If carriers choose to send letters to the MAOs, how many attempts are appropriate?
Well, there's no definitive guidelines on that, right? But I think that, you know, a couple of attempts would be sufficient. And at a certain point, if the Medicare Advantage plan does not respond or timely provide you with a demand, I think it would behoove you to move forward with settlement. There's only so long you can wait. We don't have any official guidelines or parameters around that. But if you'd like to talk to us specifically on what might work for your organization, please feel free to reach out.
Perfect. And then last question, how far back will they look for penalties? Do they still look back to, do they still only look back as far as the rule issuance date?
So we'll see what the final rule says, but the proposed rule said that any penalties would be prospective in nature. However, Medicare does have a 5-year statute of limitations. And so to the extent that the statute of limitations has not been triggered, right? If you've never reported a claim or settlement, you haven't triggered Medicare statute of limitations. So I believe they could go back to some of your historical claims and settlements if they've not been reported. So you might want to pick a reasonable point in time and going back and, you know, getting your data up to date, whether it be 3 to 5 years at least, and make sure that all of your data is reported to Medicare. A late report is better than no report. And again, a common pillar throughout the proposed rule for Section 11 penalties was Medicare wants to see good faith and efforts to report. So long as you're, you know, putting those good faith efforts in, I think you'll be in a good place.
Perfect. Well, that was it for our questions, I think. So again, we want to thank everybody for joining us and taking their afternoon to spend with us. If any questions come up, in addition to what we've already answered, again, please feel free to reach out. And if you'd like a copy of the presentation or the link, you can reach out to us as well.
All right. Well, thank you, everyone. Bye-bye.
Thanks, everyone. Bye.